Good afternoon, everyone. My name is Merritt Green, and thank you for joining us today for a primer for realtors, death, divorce, and real estate. If you're a realtor, I'm glad you could make it here with us today. We'll do introductions in just 1 second, but let's go ahead and get the presentation going. I'm going to say this for Joanna, although we're all lawyers here doing the presentation, but none of this should be taken as legal advice. You should retain an attorney or have MBH do your settlement for such matters. This is just hopefully good information to help you do a better job when representing your clients. So with that, we'll just do a quick overview of General Counsel. General Counsel was founded in 2004, full service law firm for individuals, nonprofits, and businesses throughout the area. Joanna leads our divorce family law practice. Ann-Marie leads our wills, trust, and estate planning practice, and also does a lot more business succession planning with business owners. And then we also have 4 other practice areas, which is business law, litigation, government contracts, and employment law. So with that, Joanna, why don't you go ahead and introduce yourself, and we'll keep going.
Absolutely. Thank you so much, Merritt, and thank you to the co-panelists today. Very excited to be discussing this topic. And thank you for doing that disclaimer. Merritt and I do webinars often, and you know, it's just that some of these topics can sound like, oh, that's exactly what the situation is that I'm dealing with. But you know, with every property that's selling or divorcing couple in my field, there are so many variations. So definitely reach out to the appropriate attorney if you need one. But so hello, my name is Joanna Foard. I lead the family law practice of General Counsel. I exclusively practice family law. I enjoy it very much and often deal with parties who are placing real estate on the market. So it's a wonderful topic and very relevant, definitely. There are a few accolades, I guess, about me. If you go on to AVVO, that is a website that I send a link out asking former clients for reviews, and somehow, without paying any of them, I've received, I think I have 135 now, all but 1 are 5-star, but if you read the non-5-star, it's very complimentary. So, you know, it just shows that it's real, I guess. But I take my work very seriously. General Counsel is a wonderful firm to be at, and I look forward to hopefully assisting, you know, anyone that's on here, answering any questions. This is, like we said, a great topic and very relevant.
Great. And I think that's important, is just for the realtors that are watching here today, to use all of us as a resource. You know, if you have clients that are going through a divorce, or, you know, someone just passed away, you know, hopefully you can contact us just to ask some questions. All right, Ann-Marie.
Hello, thanks again for joining us. And again, I thank the panelists and Merritt for hosting this. I specialize in estate planning, and specifically when it comes to real estate, estate planning, the intersection there could just be bumps in the road for all of you. So I hope that you enjoy this webinar. We give you a few tips regarding divorce, but also title issues and estate planning, and hope this is actual advice that you can use. But again, give us a call if you really want to have legal advice for your specific situation.
Great. And Ann-Marie also has some wonderful reviews. In fact, I saw another one that came through this morning. So that's wonderful. And then, Laura, if you want to go ahead and introduce MBH and yourself, although I assume everyone watching today knows who MBH.
Yes. Also want to thank you, Merritt, and everyone for having me here, letting me join in on this webinar. This is a great subject. At MBH, it comes up a lot. MBH, as some of you may know, we've been around for almost 30 years now. In the Virginia area, but also in DC and Maryland. As it says here, we have 20 locations across the DC area, and we do all of your real estate title settlement needs in all 3 jurisdictions. I'm in our Bethesda office. I'm a settlement attorney, but I am licensed in DC, Maryland, and Virginia. I'm from this area, like it says. I went to GW for law school, And I actually practiced family law at a firm in Virginia prior to doing this. So I am also familiar with some of these issues. Definitely still call Joanna for those issues. If you need divorce advice, call Joanna. But I am here to help you with issues that come up when you have clients on the real estate transaction side that are divorcing or when there has been a death.
Wonderful.
So with that.
Great. And within the GoToMeeting toolbar that everyone should have, it has a place where you can ask questions. Please go ahead, type in your questions, and as we go along, I can ask those and we can get them answered. And hopefully we'll get a whole bunch of questions. So with that, we are starting with divorce.
Hello again. So when thinking about how to approach this, and the most common issues that come up, I thought of like the 3 key things, and then I'm going to discuss in detail about them pretty briefly. I could go on forever, but if there's a topic that's discussed that you want more information on or have any particular questions, feel free to type them in along the way, or if you'd like to discuss privately, my contact information will be at the end. Email me. Email's the best way to get me, and I'm happy to discuss. So the first tip that I would say would be confirm important details in writing. So, when it comes to a divorcing couple and property that's being sold, my advice would be to have an attorney be involved to assist. But if there is no attorney involved, be sure to communicate via email or text message to protect yourself. For example, someone might agree to something on the phone, and if so, follow up with a confirmation email. This will protect you if the party becomes wishy-washy or even denies agreeing to the particular terms at some point. Remember, divorce is a very stressful time for people. So even the people with the best intentions might, go back and forth on things, or even honestly, due to the emotional distress, honestly might forget agreeing to something. It can be a very difficult time with a lot going on. If there are minor children, their head might be otherwise. So in order to protect yourself, definitely confirm important details in writing. Also,
you just mentioned something. I'm sorry to interrupt you.
No, come on.
Separation period. So you mentioned a family with children. So if someone just, is contemplating getting divorced and they contact a realtor, they can't just automatically put the house on the market, or I guess they could, but there's a separation period, here in Virginia. You talk about that a little bit?
Absolutely. So essentially, in order to file for divorce in the state of Virginia, there is a required separation period. If there are no minor children of the marriage, it's a 6-month separation period. And if there are minor children, it's a 12-month, an entire year separation period before you can file for divorce. Now, that's not to say that, people often call me, sometimes even before they've separated. And
we would recommend that you'd call Joanna before you even separate.
Just call me. Whatever's going on, just please don't sign anything. Call me first.
In fact, you should probably call Ann-Marie also to update your estate plan, if you're thinking of separating, because the last thing you want is to be, separated from your current spouse and get hit by a bus, and that spouse that you no longer like get all of your money and insurance and 401k.
But then I'd have to loop in Laura to see how the property is actually held. Is it his husband, his wife? Is it just the wife, just the husband? So
Yes.
we're all involved here.
This is really fun. We went from confirm in writing to somebody dying. We're just a full service webinar for you, ladies and gentlemen.
Yes.
Well, Joanna, when it comes to selling property or just the property aspect in divorce, what important details do you advise people to confirm in writing?
Well, that's a great segue to item number 2, where I would, strongly encourage divorcing parties to have an agreement before the property gets even placed on the market. And whether, while I was preparing for this webinar, I also thought it doesn't have to be a marital settlement agreement just for divorcing parties. It could even be a prenuptial agreement for people that are in a relationship purchasing property together, because those important details, like you're saying, Laura, which there is a long list of them. I tried to, include some. So essentially, if a home is being placed on the market, if there's a mortgage, who's paying that mortgage? If things need to be fixed up, a lot of times you hear, oh, if you put 5,000, 10,000 into it, you can get 20,000 back. So who's making that determination? If the parties disagree, can one party pay? Will they be receiving, more of the net proceeds off the top? What if someone has a pet that totally destroys, something in the meantime, they've moved in? What if both parties vacate the property and some damage occurs during the meantime? Who's responsible for that? So essentially, by way of either a prenuptial agreement for non-married parties, or even a postnuptial agreement if the parties are currently married, divorce, they're not filing for divorce and don't even ever have to file for divorce, but a postnuptial agreement is a document that can be prepared for married parties that essentially, like a prenup does, but you're already married, and can distribute assets and liabilities of the parties. And essentially, if you go through the divorce process in the state of Virginia without either a prenuptial agreement or postnuptial agreement, then it's going to be, the state law. It's going to be followed. And if the parties agree to another division of the assets or liabilities, then that can be included in the agreement, executed properly with the correct witnesses and all of the necessary things that you need to make sure that it's deemed valid, and that can protect everybody.
Joanna, what about for the realtor and a couple comes to the realtor and says, we've been living here for 10 years, we have kids, we have joint bank accounts, and we've been holding ourselves out as married for the last 10 years. We've never officially been married. We went to Vegas once and had a little fun ceremony, but we've never been married in Virginia. What does that mean for the realtor?
So
I'm sorry, and the title is just in one of their names.
I was going to say that would be great for like the third topic, because essentially assisting the parties to understand how the deed is going to be written, not necessarily the realtor's responsibility, really more the attorney, but the parties understanding how the deed is titled and how the mortgage or mortgages or HELOC or whatever's going on is titled could absolutely be detrimental or, save someone, because a lot of people don't understand.
Can I just jump in? So you said it wasn't the real estate agent's responsibility, but I just wanted to put it out there. We all know that, you sort of need a nudge, and sometimes the real estate attorney can sort of educate the client and like nudge them in the right direction. And they have more of a checklist of things to do. Sometimes attorneys get so busy. It's just so important that the real estate agents are on top of these things. So,
well, and for that realtor, who's their client? If only one of the spouses or one of the couple is on the title, do you really have both of the couple, if they're unmarried and only one of them's on the title, as clients? It would be sort of, you have to figure that out first.
Absolutely. And a lot of times in family law, unfortunately, when parties are in a great place together, trusting each other, there could be a lot of promises, verbal agreements that never make it to writing about, oh, we'll just put it in my name, the deed, or, I'm just going to put you on the mortgage so that, there are things that are said that aren't necessarily going to transfer when it comes to sale of the property. And it could be very detrimental if parties are signing off on things. That's why I always say, talk to a lawyer before you sign anything, because if you're coming to an attorney before signing anything, we can help you avoid situations that you might be getting improper information. Somebody might just be trying to sway a person, oh, no, it's fine, I talked to so-and-so, oh, okay, versus understanding your rights and obligations.
Well, and if anyone has any questions, realtors, about, like you were saying, Merritt, who's my client, who needs to sign this contract, listing agreement, whatever it is, closing documents, your title attorney can always help you with that. That's not necessarily the same question, though, as who might be entitled to proceeds or have a claim on those proceeds once the house is sold. That can be a different, right? Correct me if I'm wrong, Joanna. But we can always help with who's on title, who needs to be signing these documents, but there could be other implications once the sale is made for who might have a claim on those proceeds, to include someone who's not even on title.
Most definitely. And like we said before, this is a topic I could go on and on. I'm seeing that I'm just around the 10-minute mark. So I'll kind of conclude here. And then if at the end we want to jump back in, I'd be happy to do so. But in summary, I would just say, make sure that you get everything in writing, confirm that the communication is clear also and ambiguous, no confusion, try to be concise with those confirmation emails to protect yourself. And also, number 2, I suggest hiring an attorney and use that third party to iron out details. I made this joke, don't mute me, Merritt, but I said to avoid a future heartache or maybe wallet ache of your clients. I'm sorry. I had caffeine this morning. I haven't in quite a long time, and I have a 3-month-old, so I'm a little loopy. But seriously though, some people might end up in a financial situation that they really did not understand. So getting that information beforehand, and also whoever's names end up on documents, deeds, mortgages, etc., making sure that they understand those rights and obligations.
Yeah, and I think one of the things that really to highlight, and I've heard horror stories, is the couple, when they're going through the 12-month of separation period, you can't file a divorce until you're finished with that. So the court doesn't really have jurisdiction to tell people what to do with the home until you can file the divorce. So you almost have a limbo period where if you have a couple who's married and let's say one of the spouses moves out and the other spouse is in the house, perhaps not very happy about the whole divorce situation, may not want the house to get sold, may not be cooperating. And you have to sort of think through as a realtor, what do you do in that circumstance? And it can be a difficult situation, and perhaps there's not much you can do. All right, anything else with that? So let's keep moving. And Ann-Marie, we are all yours.
Terrific. So I'm just going to touch briefly on 5 different issues that I think will be best practices or tips for you. I'm sure many of you have had your own war stories or have heard about situations when death and real estate are involved. It can slow things down. So my first tip is obviously to set expectations of the client. It's really easy for you as realtors to say, oh, I can fix everything, don't worry about it, which you can ultimately, but just give them an idea that if death is involved, everything seems to slow down, and things have to be done very deliberately. This is whether there is a will or a trust or people die without a will. Either way, the whole process slows down. And whether it's just having the family decide what's going to happen to the property, that's the first thing, or the second thing could be, locating the estate planning documents if they haven't been communicated before. And of course, I'm sure you guys have all heard about, what to do with the contents of a house. That could be something else that's up for debate. So those 3 issues come up all the time. And so just set expectations that, while there's going to be challenges, that you have a good team. You have all of us you could reach out to. You can just tell your potential clients that, yes, I've done this before, and even if I have a question that I can't answer, I have people that are vetted already, and we can reach out to them and have their questions answered. So that's my first tip. The second one is in the trust scenario. So if you happen to have a client who has property held in a trust, and again, a trust is a legal vehicle that can hold property, can hold an LLC. One of the most important things is to check the name of the trust, so you can get that from your client and make sure the name of the trust exactly matches what's on the deed. I see Laura shaking her head. Do you want to jump in on that?
Just that's definitely an issue that we see, where the name either isn't quite right, or honestly, sometimes people forget they've put their property in the trust. So they enter their listing agreement, they sign the contract in their individual names, and then the title search shows that the name is actually held by a trust. So it's not impossible to cure, just an amendment or an addendum to that contract, updating the identity of the seller as the trust as opposed to the individuals. But that's definitely something that happens, that either it's not quite the right name, or it's not, they forget that it's in the trust name at all.
Yep, so exactly. So it just is a minor bump in the road. It's not that it's not fixable, but it's just something that you can check. And they need to look at their certification of trust or certificate of trust, and that's how you can find the exact name. And the next issue that happens is if you have any costs and fees are going to be paid relative to the property. If the property is held by a trust, you have to make sure that the bank account is associated with the trust as well and the exact name. So just have them show you the account statement, and you can compare all three things and make sure everything is aligned. The next topic is a pour over will. Just to give you a concept, this is something that attorneys normally have their clients execute when they're doing a trust. It's just a backup document. It's not a long drawn out will. It's just a document that says, look, if things are not placed into the trust when I pass away, judge, please pour over all of the property into my trust. That's what I want. I want everything to be held by the trust. And so if the particular property is then poured over into the trust, you think that there'd be no problem. However, you have to wait for a court order to actually have that done. So it slows things down. So again, it's not a problem. It's just one of those bumps in the road that if you know that they have a pour over will, you have to set expectations and say, you know, I know what this process is. It is workable, but we have to wait for a court order to have this property be placed into the trust before anything can happen next. Any thoughts on that one, Merritt?
Well, what I was just thinking as we're going through this, and this is probably more applicable for someone having a will or even passing away intestate, is, you know, as a realtor, you have to know how long the probate process could be, you know, and if the house is going through probate, you know, whether it's a will or dying without a will, you can't just put the house on the market, or if you do, you have to set expectations that you might not be able to sell it for 6 or 12 months, you know, and if it's contested, perhaps even longer. Is that right?
Mm-hmm. Yeah, it can take 4 to 6 months, but the good news is during COVID, just like a lot of other businesses, the courts actually had to learn how to pivot and take things online and streamline everything. So the process is still relatively slow, but it's easier to check things, check the status of things. It's more manipulable, and you have fixed time frames that people need to get back to you. And sometimes it's easier to get the hold of the court now than it was in the past. So one positive thing about COVID, that the courts are more streamlined when it comes to probate, but it still does take a long time, to your point. Yes.
Laura, is that something that you've seen, you know, or problems with sort of homes going through probate and when you can sort of do the settlement, you know, and issues associated with it?
Yeah, we're usually towards the end of that process, so we try not to have people putting them on the market and getting them under contract when they don't really have the ability to do that. But we definitely see it, making sure that, and I'll talk about this, but making sure that they really have the power, the legal right to sell the property when they're trying to do that.
Yeah, I'm sure it's something a lot of, you know, if your parents pass away or they're surviving, you know, your mother passes away and you have 3 kids who live in a, you know, foreign jurisdiction, you know, inherit the home, they probably want to sell it as soon as they can. They may not realize that they can't, you know, that there's going to be a process. I think that's something the realtors really need to be aware of.
Mm-hmm. And I just wanted to pick up on a nuance for the next one, for number 4. We were just talking about, you know, people who are in another state, you know, if you have more than one beneficiary, or in the one situation, if a minor is named in someone's will, just if someone is, you know, below 18, and sometimes, you know, they're named in a will, then the whole process slows down even more because a guardian has to be appointed first, or a testamentary trust has to be created to hold this property until the child becomes age of majority, or someone's going to manage it on their behalf. So you do have to check the will to see and determine the ages of the potential beneficiaries.
Mm-hmm.
You know what this makes me think of? Just sitting, I mean, I'm learning a lot, to be honest, but it just really reminds me that seeking an attorney's assistance, really just like specifically the wills we're talking about, if there's property owned, and making sure things are written in a certain way to help avoid these delays. And, you know, we're talking about delays that can occur. It's going to be more expensive too. You know, that's more motions to prepare, or whatever it is, going to court. So it's just like a good reminder that having documentation demonstrating and supporting what your wishes are, whether that be a will, whether it be a divorcing party through an agreement. You know, in my world, it's just, it can really help so much.
Absolutely. Just, written communication, instead of just an oral understanding between the parties, and, just thinking about all these different contingencies. So yeah, you're totally right. And on that note, if someone happens to die intestate, so without a will, without a trust, one important thing, for realtors to consider is to make sure you get something in writing about your fees, how they're going to be paid, on what schedule they're going to be paid. That's something you can do with intestate. If the parties have agreed to work with you, if you're going to be the real estate agent for the family, don't be shy about it. Just, have them put it in the court order. How am I going to get paid, and what account this is going to come from, and what's the percentage. So you can, ask judicial guidance for that, and it's not something you should be embarrassed about. It's to get those terms in writing so you're actually getting paid. And then just another tip you can suggest to the families, if for some reason more than one person is going to inherit a particular sale of a property, I would advise that you suggest to them to have a trust created so they can receive their share of the real property if it's not going to be sold right away, or the proceeds from the property into a trust. That way, if anything happens to them, they can set where that's going to go next without having to go back to probate, because trusts stay out of court. So it's you're actually giving them cost savings to recommend to have the proceeds or their share of the real estate put into a trust versus just accepting it outright.
Ann-Marie, just so I understand that, so I'm sure there's a fairly common, you have mom or dad passes away, they die intestate, so no will, 3 kids. So are you suggesting that they potentially make a trust to hold the house, so the 3 siblings do it together, or how would that work?
Yeah, separate. So no. So once the house is distributed from the court, that they distribute it to each individual sibling's own individual trust. Not that they hold it together as a trust,
Gotcha.
but they all have their own share within the trust. It's an easier way to handle it, to already pre-separate their shares. Or if they're going to just sell the property, through an executor, or a trustee is going to sell the property, then it gets liquidated into their separate pieces. I have to get careful with my nails. I'm doing that again, huh?
No. Well, and the complicated part could be, what happens if 2 of the siblings want to sell and the third one, thinks it'd be a great place to live. And what do you do in that situation? I guess you would ask the court to force the sale. You don't have a partition.
Correct. And they have to present evidence to say, why they think it should be done. And mostly it goes on the economics of it. And the court usually does, lean towards sale versus, having people bought out, I guess you could say. They lean toward the economic analysis because it's objective and there could be evidence towards that.
Mm-hmm. So, one final tip for realtors who are sort of listening today, they're contacted by a client, if someone's passed away, what should they do?
Call me.
Mm-hmm. I guess so. And make sure how the property was owned.
For sure. Make sure how the property is owned, but see if you can assist them in finding the state planning documents of the particular party, even if they were executed a long time ago, just to get some guidance of what the person who passed away wants or wanted. And then, next steps, you can walk them through what the next steps are. But every situation is so different. But I think most importantly, they're going to lean on you to educate them. And you can just tell them that you have a team that can reach out and help you if you have any questions, and that you can get through it. It's going to take a little while.
And the other thing is, lots of times, folks have to consider estate planning, putting a will or trust in place when they have major life events. And one of those major events is buying a home. So really one thing that I think realtors can do is, after someone buys a home, say, congratulations, if you don't have a will or a trust in place, now is perhaps the time to think about it. And you may want to put the home in a trust. So in that regard, and Laura, this might be a question for you, is it better to sort of, if you're buying a home, it's your first home for a young couple, do you perhaps put the trust in place first, as opposed to doing it after you bought it?
Not necessarily. And when you're first buying the home, your lender is going to have a say in things like that. Once the house is purchased, you can just transfer it with a deed to a trust pretty easily. When you're in the purchase process, there's a little bit, not to say you can't do it then, you absolutely can, but there's more parties involved. Either way, you're going to need to let your lender know if you're transferring title, even if it's after the purchase. But really, either time is fine.
That is a really good point also about having the mortgage on the property. You know, that's something else that has to be handled, you know, how the mortgage is going to get paid off, and also, you know, what the mortgage company's requirements are. Sometimes they have specific requirements. They will only communicate, you know, after there's been a court order, or they'll only communicate if there's been, you know, specific requirements met. So you have to make sure you definitely check with the lender to see what those are ahead of time. And that's something you can do as a realtor too, is you can follow up with, you know, the company directly and get the information, or at least tell the clients what they should be asking.
Great.
And if you're, I know we focus a lot on Virginia, but in other states like Maryland, there's first-time homebuyer programs, which you're going to want to make sure you're qualifying for if you are a first-time homebuyer. That's going to influence your decision about whether you're buying in the name of a trust or in an individual capacity.
Right.
So I'm going to talk now about 5 tips for a smooth settlement when you're having a transaction involving death or divorce. So some of this is going to sound a little familiar, but looking at it from a slightly different perspective, looking at it from the title perspective, and making sure that we can ensure, which is the name of the game on my side. So number 1, if the property owner has died, has passed away, make sure that your seller has the right to sell the property. So we've touched on this, but it's a really important one, because if the sellers don't have the legal right to sell the property, your transaction isn't going to be able to close. So it's a big one to figure out ahead of time. If the property owner has passed away, there's a few ways that the seller can have the power to sell. And the first, of course, is if that seller is already also a record title owner to the property. Another record title owner is always going to have the power to sell. Example is if your sellers were married and own title as tenants by the entirety. If one spouse dies, that surviving spouse is going to have power to sell the whole property. You're going to need to provide a death certificate to the title company, but that's all you're going to need to do in this instance, because that surviving tenant by the entirety is going to have the power to sell.
It may be lunchtime, but I'm thinking about the pizza example. So if you can just relate it to a pizza. So they, you know, when you have that situation, tenants by entirety, you're saying that they don't necessarily own half of the pizza. They actually both own the whole thing. Go ahead. You can.
Exactly. Yeah. And there's a right of survivorship that comes automatically with that. So kind of don't want to get too much into the weeds, but essentially when that one spouse dies, automatically by operation of law, their interest in the property transfers to their surviving spouse. So there's nothing more that needs to happen, no other deeds or transfers that need to be recorded. That's done. It does, of course, get a little bit murkier, which is why, to Joanna's point, every situation is different. Call an attorney if they own property as tenants in common or even joint tenants, things like that. Every situation is different. Give me a call and we'll walk through it. But if they're on title, they at least have the power to sell their interest. The question is whether the decedent's interest has also automatically passed to them.
Oh, I just wanted to jump in another scenario that we had recently. Someone called and the property, they had a life estate in the property, and their father had passed away, and he had a life estate in the property, and that it was supposed to revert back to a different sibling. And so that's another way property could be held.
Mm-hmm. Laura, are you seeing that most people, most married couples are holding tenants by the entirety?
Yes, most do, and we usually advise that they do because it protects them against creditors better than any other way that they can hold title. They don't have to technically, but it's only married couples can hold property as tenants by the entirety, and it's advisable just for the added protection from creditors.
What about a scenario where you have a couple tenants by the entirety, and one of the spouses you know, is in assisted living, you know, perhaps on life support and has been there for a year. They don't have any sort of estate planning, so no power of attorney, Ann-Marie. and they want to sell. The one spouse who's not in assisted living wants to sell. What can they do in that circumstance?
They're going to need some sort of power of attorney for that spouse who is still alive, even if hopefully they've had that done ahead of time. If there's a capacity issue, we can also help with powers of attorney to sell property. If they're in assisted living, that doesn't mean they can't sign a power of attorney. It just depends on kind of their each unique situation. But so long as that surviving spouse is alive, either she will need to sign or she'll have to execute a power of attorney to transfer her interest.
No, but I mean, it's, again, as a realtor thinking through this, you have, a spouse comes to you and says, my husband or wife is in, on life support, and, they can't sign anything. It's sort of, you have to figure out, again, who owns the property and what they can do. And, I guess in that circumstance, we might have to go to court and get a power of attorney.
Right. Or you could have a court order, because the courts can do more than we just can with a deed or something like that, or a power of attorney. But a court order could deal with that. But you're going to have to do something if that's the situation. Which
again makes it all the more important to make sure that folks are doing that pre-planning, the estate planning. When Ann-Marie and I have done these webinars before, we sort of talked about not really estate planning, but it's life planning, things. So you can have solutions for when these things come up. All right, keep going.
Yeah, so if they're not on title, then if the owner has passed away, then it's possible the executor has been given the power to sell the property in the will, and the will should state whether or not that executor has the power to sell. Alternatively, it's also possible that the property was devised in that will to specific heirs, in which case those heirs would also have the property to sell. I usually recommend the best course is to have both the executor and the named heirs sign your sale documents, listing agreements, contract, and closing documents. But when heirs are spread out geographically, that's not always feasible. So in that case, so long as the executor has been given expressly the power to sell in that will, then you can have only the executor sign the sale documents. But if that's not the case, if there's no power to sell, you're going to need all the heirs to sign. If there's no will, if the owner died intestate, then there's going to be a list of heirs that needs to be filed and recorded with the county. And the court could also appoint an administrator of that estate. So once all those heirs are identified on that list of heirs that's recorded with the county, you're going to need those heirs to sign all your sales documents. The only real situation in which you wouldn't need all of the heirs to sign is if the administrator was given an express power to sell. But Ann-Marie can correct me if I'm wrong. That's not usually given automatically by the court. They would need to go specifically to the court and ask the court to give the administrator the power to sell. So generally, if the owner died intestate, you're going to need all of those heirs to sign your documents. And the thing to keep in mind on this is that your title company is going to have to review your relevant documents to show that the sellers have the power to sell. So my advice is just let your sellers know ahead of time to gather those important documents so they're ready to give to the title company to review. So that's going to be the will, list of heirs, any court orders, things like that, and of course a copy of the death certificate.
And so I have to jump in there. Also need the sometimes you need the birth certificate, and if the person who passed away was married and then divorced, you might need those as well.
Yes, and of course any trust agreements. A lot of times, as Ann-Marie was saying, people are holding title in the name of a trust just as an estate planning tool. If that's the case, totally fine, but we're going to need to review those trust documents to make sure that the trustee has the power to sell, just like anyone else. You're going to have power to sell the property. So number 2, make sure your sellers know ahead of time that the sale proceeds must go to the sellers as they are named in the contract. This is also a big one. If your seller is an estate, so the estate of John Doe or a trust, the John Doe trust, the estate or the trust has to have a tax ID and a bank account where those proceeds can be sent. You don't want to get all the way to the settlement table and get a check for your proceeds made out to the estate and have no way to deposit it. This one can be especially confusing to some people because they're signing the documents, their name, and not always realizing that it's their name, Mary Jane, as executor of the estate of John Doe or as trustee of the John Doe Trust, and they're not actually signing in their individual capacity. The seller is really that entity, and the individual signing is just an agent. So the funds have to go to that estate or trust. They cannot go to the individual's personal accounts. So that's just something, it's not hard to remedy. They can get a tax ID and set up that account. It's just something that needs to be considered and talked about ahead of time, so they have time to get those things going. Number 3, when your sellers are divorcing, it's good to familiarize yourself with any court-ordered terms of the sale. So as Joanna was talking about, putting terms in writing. So if they followed her advice and they used Joanna, they have all of these terms already agreed to, and it's common in divorce for those agreements or court orders to specify details relating to the sale of real property. It makes sense. You want to give them as little as possible that's left up to the parties if they can't agree. So the idea is to get those things agreed upon ahead of time in writing. And they can range from everything from what the list price of the property should be, what offers they can accept, how repairs and improvements should be apportioned between them, and how the proceeds should be divided. So as their agent, you just want to be aware of any terms or conditions relating to the sale that have already been agreed upon, that the parties are already bound to. And it's best to see it in writing if at all possible. Best way to do this is just to ask for a copy of just the relevant portions of any court order or marital settlement agreement that relates to the sale of the property. You don't need to know all of the details of their divorce, but just those relevant portions, just because you want to know if there's already been terms that the parties are already bound to adhere to.
Yeah, along those lines, and I know something that Joanne really talks about a lot, is having that marital separation agreement or settlement agreement be extraordinarily detailed. You know, if I'm a realtor coming in and you can tell that it's a messy divorce and the people don't like each other, I would insist not only in seeing the relevant terms of that settlement agreement or court order, but perhaps even putting another agreement in place if it's not sufficient, you know, and having their respective attorneys write up something just dealing with the sale of the house and who's going to be responsible for care and upkeep, and, you know, making sure that you can do open houses and viewings, and, you know, that someone that's living there is not leaving dirty dishes everywhere and dirty clothes around everywhere because they don't want the house sold.
And even how everything is going to be communicated, you know, who's going to email who and who's going to be the point of contact and all of that.
Oh, and what the prices are to accept an offer. You know, I've heard of situations where one spouse says, no, we're not selling it for a penny under 1.5 million. And the other spouse just wants to move on with their life and sell it for 1.4. And what happens in that situation? It's a really difficult situation if you don't have it in writing, and, you know, you have to figure that out.
Absolutely. And I know, Laura, in a past life, you were a divorce attorney and you saw these things. So I would just say to, you know, the realtors watching, if you are able to participate in the process when that agreement is being drafted, or as Merritt's talking about, if there's some type of addendum or just something in writing, you know, after the fact, maybe even just listing the person's name who has been decided, because that's something that can delay sales forever, not agreeing on the realtor. So, you know, if it is agreed, who the realtor will be, putting that in writing. And also what Merritt's saying, a lot of times what I will do is put that it is basically in the sole discretion of the realtor to put the sale price, because you're trusting them as a professional. They're going to know the market, and, you know, it's in everyone's best interest for it to not be listed completely, you know, the low price or something. And like Merritt's saying, you know, a lot of people, especially when you're dealing with divorcing parties, they're not, even people that love each other and aren't divorcing sometimes can disagree on a sale price. So, you know, as much specificity as you can get in there to remove the burden from the realtor, and also, Ann-Marie, like you're saying, the parties having the opportunity to, go back and forth, it's best to have that specificity.
Joanna, just quickly, and I guess Laura also, have you ever seen a situation where a couple in a divorce is so bitterly fighting that they can't agree on a realtor?
When you were saying, have you ever seen a couple so bitterly fighting that, I just want to say yes, because I feel like at this point I've seen it all. But oh yeah, I mean, one time, and it was a litigated divorce. They could not agree on the realtor, so much so that I had the plaintiff, the petitioner, have a list of 3 names. The defendant, the respondent, lists 3 names. We gave it to the judge, who basically did eeny, meeny, miny, mo to pick one of the 6, because it was so, and I'm just sitting there billing for my time thinking this is so stupid. But again, like the most details that you can cram into an agreement, the better off everyone will be.
Good.
Right.
All right, I think we have a question here, and I think it is for Laura, for you. If a property is held in a trust, or a property held in a trust is sold and the sales proceeds are required to be directed to the trust, is it possible for the owner of the trust, who's not deceased, to subsequently withdraw some of those funds and deposit them into a different account? And I don't know if that's for you, Laura, or for you, Ann-Marie, I guess. So properties held in a trust, it's sold.
It depends, but it depends on the terms of the trust. I don't know what your comments are going to be on that, Laura, but it depends on what the trust says. I mean, there's different kinds of trusts. There's a revocable trust. So let's just say the money was deposited in a revocable trust. So generally, if you're complying with the terms of the trust, not looking at them individually specifically, then you can take the monies out and put it into a different trust or put it someplace else. But it's an irrevocable trust that the monies went in, then you couldn't take them out. So I hate to sound like a lawyer, but it depends. What do you think, Laura?
Yeah, I think the important part of that from the settlement perspective is that when the first transfer of funds is going to an account in the name of the trust. And that's what we care most about. After that, like she said, it's going to depend on the terms of the trust. It does, rules are a little bit different if you have a revocable trust and the trust creator is still alive. They're the sole trustee, they're selling the property. If you have a very specific kind of situation, things can be a little bit different in terms of dispersing those funds. But from the settlement perspective, as long as the first disbursement of those settlement proceeds go to the trust, from there on, it's a trust question, and I would defer to Ann-Marie and the terms of the trust on that.
Very good. All right. And I think we're on number 4, so there you go.
Yes, so number 4. So if your clients didn't go talk to Joanna beforehand, and they don't have these terms that have already been addressed in a court order or an agreement, my advice is talk with your sellers early on in the process about who is going to cover the cost of any work that needs to be done on the property. So for example, if the buyer's inspection shows the garage door needs to be repaired, or painting needs to be done, or there's a plumbing issue, talk about who's going to be responsible for those, making sure those repairs get made, and for how the costs are going to be shared. I have been in the situation where sellers of the property were divorcing, and on the date of the final walkthrough, the buyers discovered that none of the repairs that the sellers said they were going to make had been made. So the buyers came to closing but refused to sign anything until it was figured out. So on the day of closing, at the closing table, the listing agent is paying out of his own pocket to hire painters and plumbers and get people to the property as quickly as possible in order to get the deal to close. And you don't want to be in that situation. So talk with your sellers early on, see if they can come to an agreement on how those costs are going to be shared. As Joanna mentioned before, will they be reimbursed with proceeds from the sale? Will all sale proceeds be split? All of those things you just want to talk about early on, so you don't end up in a pickle at the day of closing and nothing's been done. My last tip here is let your title company know if your sellers are divorcing. This is extremely helpful to us in not only just avoiding embarrassing missteps. We walk in, congratulations, this is such a happy day, if it's not, but it also just helps us be prepared. Divorcing sellers are sometimes more anxious at the table. They want to talk more about what everything means for them financially. It just allows me to be prepared when I'm walking into closing and know what I'm walking into. They also might want to schedule separate signings, which is totally fine. We have to schedule that ahead of time so that the sellers can have separate signings if they want to do it that way. And then we also just need to know how proceeds are going to be dispersed among the sellers, in which percentages or amounts after settlement. This is important not only so that we know how to disperse the funds, but also because it will directly inform how we report the sale for tax purposes to the state and federal government. So it's important that we know that early on so that our tax reporting documents are accurate at settlement. So those are my 5 tips for a smooth settlement. But if you guys have other questions, specific scenarios, definitely feel free to reach out to me. Happy to talk you through whatever you have going on. Oh, and there's my email address, everybody's email address.
There you go. So across, Joanna, Ann-Marie, and then Laura, sort of one thing you could tell the realtor that's listening here today, to do as it relates to your particular area of expertise. Joanna.
I'll start. I would just say getting things in writing. Hopefully people will hire an attorney. Hopefully it'll be early on, but we all know that's not always the case. So if there's no agreement and no attorney, just protect yourself and get things confirmed in writing.
Or perhaps recommend that they, get an attorney in place or 2. So, Ann-Marie?
Mine would just really goes to the bottom line, about the money. They're concerned about how much money they're going to receive from the sale, and you're concerned about your fees are. So just be upfront about it. Be a straight shooter and say, how are we going to work this out? That's be my advice.
Laura?
Mine would be just ask questions so you know how the property's titled, how they see this happening, how they want to split things, just so you can be informed. If there are terms of the sale that have already been agreed to, just familiarize yourself with how they see this going down. And if you have any questions, just call. We'll talk to you about how property's titled or how to move forward. So.
Wonderful. And we have one last question that was asked, which is, do all of you only practice in Virginia? Well, I know MBH is all over DC, Maryland, and Virginia.
Yep, I do all 3.
Excellent. And Ann-Marie, I know, is New Jersey, New York, representing clients in Virginia. I don't know about DC and Maryland. Probably DC, yes?
But we can co-counsel in any other state.
Yep. And Joanna, I know the answer, but why don't you go ahead and you can tell us yourself.
I'm licensed in DC, Maryland, Virginia, and Florida. I primarily am taking cases in the state of Virginia, but Maryland and DC I have as well.
Excellent. All right. Well, with that, thank you everyone for participating today. Thank you, Joanna, Laura, and Ann-Marie. And if you have any questions, please email any of us today. And thank you so much.
Thanks, Merritt.
That I will try and end it. All right. Take care. Bye-bye.